Good afternoon, everyone. Thank you so much for being here this afternoon. For those, I guess Bob is going to be speaking from this podium, but I guess he can speak to everyone in the room comfortably. I hope that's all right. You guys can stay where you are. We are really excited to welcome Bob Ambrogi to the law school today. I decided that Bob was the guy that we had to come to be the sort of keynote speaker for our last event at Legal Tech Week because I receive his, are they daily, Bob? It sometimes feels that way. At least weekly emails about legal tech. He has just become, in my mind, and I think the nation's mind, lawyers everywhere understand him to be the journalist who really is at the cutting edge on understanding legal technology and artificial intelligence. He is a lawyer and a journalist. He has been writing and speaking about legal technology for nearly 3 decades. So we are going to be the beneficiaries of that lengthy learning process. He writes the award-winning blog Law Sites, hosts the podcast about legal innovation, Law Next, hosts the weekly Legal Tech Journalist Roundtable, which is called Legal Tech Week, and is a contributor to Above the Law. He also co-founded the Law Next Legal Technology Directory. In 2011, Bob was named to the inaugural Fast Case 50, honoring the law's smartest, most courageous innovators, techies, visionaries, and leaders. In 2017, he received the Yankee Quill Award for Journalism from the Academy of New England Journalists and was honored by the ABA Journal as a Legal Rebels Trailblazer. In 2023, ABA Tech Show presented him with a Lifetime Achievement Award. Earlier in his career, he was editor-in-chief of the National Law Journal, then the nation's largest legal newspaper, and editorial director of American Lawyer Media's Litigation Services Division, overseeing an array of online and print publications. Before joining ALM, Bob was founding editor of the national newspaper Lawyers USA and editor-in-chief of Massachusetts Lawyers Weekly. For his service to the legal community as editor of Massachusetts Legal Weekly, the Massachusetts Bar Association honored him with its President's Award. In his law practice, and by the way, he also practices law, he represents newspapers and the news media and serves as executive director of the Massachusetts Newspaper Publishing Association, where he lobbies and advocates for a free press and open government. A graduate at Boston College Law School, Bob is a fellow of the College of Law Practice Management and past president of the Massachusetts Bar Foundation. Bob, you're truly an extraordinary person and have had an extraordinary career, and we are just grateful to hear from you today. I want you to know that this is going to be videotaped. Is that okay with you, Bob? Videotaped? Okay, good. So that we can share it with others who are not able to be here this afternoon. And we thank you for joining us at WashU for our Legal Tech Weeks. Great. Welcome to the podium, Bob.
All right. Well, Dean Lindquist, thank you so much for having me here. I'm really thrilled to be here and to be part of this Legal Tech Weeks program. I think the 2nd annual Legal Tech Weeks, right? I have been a legal tech journalist for a long time. As a matter of fact, as it turns out, this year happens to be the 30th year in which I have been covering legal tech. I've had the unique opportunity, I think, to have a ringside seat at the evolution of legal technology, from the earliest legal websites to the kind of chaos and whirlwind that is generative AI today. I have conducted thousands of interviews, written thousands of articles, recorded thousands of podcasts. I've seen fledgling companies grow up into monumental corporations. I've seen others crash and burn. It's been a lot of fun. It's been quite a ride. So I thought that for this occasion today, what I would do is kind of talk about maybe some of the lessons that I have learned over the years that are somewhat universal about legal tech. And perhaps at the end offer a little bit of advice for any of you who are kind of just starting out on your careers here in this world. Kind kind of curious, is there anybody here who kind of works in legal tech right now as an entrepreneur or founder? At least one of you. Are there others who want to, who are aspiring to work in legal tech? Okay. How many of you are law students here? All right. How many of you have an interest enough in tech that you might want to be a lawyer representing legal tech companies? A few of you. Good. Well, let me start, before I get to my advice, by kind of going back to the beginning for myself and talk to you a little bit about what got me started down this road. Because what it was this perception that we were really at an inflection point. This was in 1995 that I started writing about this. I had, as Dean Lindquist just outlined, I'd been a journalist for a long time. As a matter of fact, I was a journalist before I went to law school, and I was the kind of odd duck who actually went to law school to enhance my career in journalism. I wasn't looking to be a lawyer ever. I wanted to get ahead in journalism. As it turned out, I became a lawyer too, and I practiced law, and I still practice law to this day. But I've always had more of my career in journalism, and the legal tech part of it really came about for me in the early days of the internet and of the web. And if I could just kind of paint a picture of what the world looked like back then, because number one, there was no Google. Believe it or not, there was a time before Google. And even if there had been a Google, there wouldn't have been anything much to find because there was nothing online. For lawyers to get access to legal information, you pretty much had to rely on the West Lexis monopoly. And most of that at that point was still books. They did have online services. They were dial-up services using your telephone lines, abysmally slow, taking forever to connect to anything. You had to have these Westlaw terminals and special terminals and no special commands and codes. It wasn't a graphical interface. For the general public, there was virtually no access to legal information whatsoever online. There was nothing online, and it was difficult to get access to legal information otherwise, other than perhaps going to your local library. And I think something else that kind of characterized that time was that there was a huge, I think, imbalance of power between big law and small law, or between big law and legal aid or nonprofit lawyers. Lawyers in smaller law firms really did not have good and easy access to legal information, to legal resources, and compared to their big law counterparts who were in big firms and had big libraries, they were often disadvantaged. If they happened to be a rural lawyer, they were extremely disadvantaged. There might not even be a law library near them. So in 1993, the web launched, what we used to call the World Wide Web. Until then, the internet was this sort of Byzantine, inaccessible, esoteric media that very few people used or understood. What was dramatic about the web was that it added a graphical interface for the first time, and it added hypertext, the ability to click on something and go somewhere. That was revolutionary. But even in those early days of the web, there really wasn't much going on there. There wasn't much content there. And slowly but surely, some, at least with regard to law, I'm not talking about the web broadly, but with regard to law, some started to put some pieces of legal information up onto the web. Initially, it was largely law schools, actually, that kind of led the campaign on that. And it might be that a particular law school might put up their state Supreme Court cases onto the website. And even then, it wouldn't be the whole backlog of cases. It would be the newer ones as they came out. So there started to be accessible legal information on the web in those early days. As a matter of fact, I was thinking about this. If anybody was at the earlier talk today where one of the professors was talking about the SEC Edgar database. In the early 1990s, the SEC Edgar database was a paid dial-up service accessible only to an elite few. There was a sort of a chaotic figure named Carl Malamud, who's still around, who was sort of pushing democratization of the law. And Malamud went in and got access to the SEC's private database, scraped it all, and put it up on the public internet, and essentially shamed the SEC into creating a public access to Edgar. That was the first government agency to put any kind of real data on the internet. There were no courts on the internet at that point, no government entities on the internet at that point. So for me, and I've gone back and forth in my career between journalism and law. At that point in my career, I was actually practicing law, and I was really attracted by the potential here. And the potential that I saw were kind of three things. One was the potential to democratize the law. And what I mean by that is simply to make the law accessible to everybody in an easy to access format. Not just lawyers, but to anybody. Second was to liberate the law. And by liberate the law, I mean kind of free cases and statutes from the monopolistic paywall of West and Lexis and make all of this generally available to anybody who wanted to access it. And then third, I thought I saw real potential for leveling the playing field, to empower especially solo and small firm lawyers, again, legal aid lawyers, nonprofit lawyers, those who did not have a lot of resources. I saw the potential of the internet to level the playing field for them. So the journalist in me kind of said, maybe I should start writing about this, because lawyers didn't know about it. There were no lawyers on the internet back then, very, very few. So what you probably can't really see here, but in March 1995, I launched a column, a syndicated column that I started sending out to Bar Association publications and legal newspapers and legal magazines. It ran all over the country for a period of time. And then from that, I launched a print publication about the internet for lawyers. Again, it was in print because there were no lawyers online back then. And that led to a couple of books, and I quickly realized that books were not a very good way to cover a medium that was changing so dramatically quickly that I then launched a blog in 2002, one of the earliest legal blogs, launched a podcast in 2005, one of the earliest legal podcasts, and here I am 30 years later, still doing this. I will say that when I kind of started down this path, I really didn't think that I would be doing this all that long. I figured after a couple of years, everybody would figure out this stuff, and there would be no more need for me to be writing about it. That hasn't happened. And in fact, as I look back over the last 30 years, we've made enormous progress in terms of technology, and obviously my coverage has expanded from just the internet into the whole panoply of legal technology as it is today. But as I look back over the 30 years and I look at all the progress we've made, we've developed some really cool technology. We have much better tools available to us. But I feel that in a lot of ways we haven't made all that much progress, and certainly not the kind of progress I would have thought we would have made after 30 years. When I look back at those kind of 3 points that interested me on democratization, well, the justice gap in this country is greater now than it was 30 years ago. There's still not reliable access for most people to legal information and legal resources. That whole point about liberating the law from West and Lexis, well, guess what? We're still paying West and Lexis a lot of money, and they are still going to court all the time to fight and protect their intellectual property. Good reasons for that. I understand why they want to protect their intellectual property, but that monopoly really still has not yet been broken. And in terms of leveling the playing field for solo and smaller firm lawyers, it's happened to a great degree. There's great software out there, things like Clio for small firm lawyers, any number of products that have made law practice better. But when you look at what's happening in the world of legal technology, so much of the money that's flowing into this field, and believe me, there's a lot of VC money flowing into this field, it's going primarily to tech for big firms, big corporate legal departments, and not so much to tech for smaller firms, and certainly not to tech for legal aid or access to justice issues. Why is that? Years ago, there was a famous bank robber named Willie Sutton, you may have heard of. I think he was in the Boston area, actually. And when somebody asked Willie Sutton, why do you rob banks? He said, well, that's where the money is. And that's exactly why VCs want to put their money into tech for big firms and big corporates, because they know they're going to get that money back. So what's interesting now this year is that I felt like 1995 was a real inflection point in the progress of legal information, legal technology. And we've had some significant points along the way. I mean, the sort of the move to the cloud has been significant. Advent of mobile technology has been significant. But I really feel that 2025 with what's happening with generative AI is truly the greatest inflection point we've ever seen in law, and that we are at a point where we are going to see more radical change in the delivery of legal services, in the practice of law over the next 30 years, the next 10 years, the next 5 years than we've ever seen before. In fact, we're actually already seeing that. You know, we see legal aid offices are making great use of generative AI technology. As a matter of fact, there was just a survey that I actually helped do, but came out recently that looked at AI use in legal aid offices and found that legal aid lawyers, overall, a percentage of legal aid lawyers are using AI to a much greater percentage than the general population of lawyers. We see courts making use of generative AI tools to be more efficient, to increase access, and the tools that are being deployed for lawyers of all sizes and all kinds of practices are really amazing. So as much as I've had a good ride these last 30 years and really enjoyed it, I kind of wish I was just starting out right now, because I think the next 30 years are going to be a whole lot more amazing and a whole lot more interesting. So all of that said, and against that backdrop, I'm going to talk a little bit about some of the lessons I've learned over these last 3 decades that I think are somewhat generic and universal and applicable to you, whatever your interest is in legal tech. And one of those is that lawyers are not Luddites, but they are very cautious. The greatest stereotype I've heard over the years about lawyers is that they are Luddites, that they despise technology, that they are slow to adopt technology. That is not at all true. In fact, I think the legal profession has been at the cutting edge of technology adoption from the start. And let me just give you one quick example of that may surprise you to know this, but going back to those days of the 1990s, do you know that one of the first ever web browsers was built by lawyers for lawyers? It was an organization called the Legal Information Institute, which still exists today. It started at Cornell Law School. And the Legal Information Institute was actually started in 1992, before the web, with the mission of doing what I was talking about, democratizing the law. They wanted to publish the law, make it generally available to everybody. And when the web came along, they realized they had a little bit of a dilemma, because the only web browsers of the time were built for Unix platforms. And of course, lawyers are on Windows. They still are, they were then. So Tom Bruce, who was one of the founders of the Legal Information Institute, had a little coding background, and he built a browser called Cello. He was also a musician, which is why he named it that. And Cello was the very first browser used by anybody on a Windows platform. So that's an example of kind of one of the, I can give you any number of examples of which lawyers have been at the cutting edge of using technology. But at the same time, we do have to recognize the ways in which lawyers have been kind of kicking and screaming against some of the more advances in technology. And I think a good example of that is the cloud. We've known since the early 2000s that cloud technology offers all sorts of advantages for deploying technology. It's a lot more affordable, it's easier to keep up to date, it's more elastic, so it can kind of grow or constrict based on the size of your firm. As early as, I think, 2000 was when one of the first ever legal products was deployed on the cloud. That was NetDocuments, the document management system. 2008, Clio came along, the first cloud practice management platform. And yet, here we are in 2025, and guess what? When you go around to the big firms and you go around to a lot of the mid-sized firms, they're all still using legacy on-premises platforms, mostly for their business management and a lot of other purposes. And you know, there's good reasons for that. I mean, there's a lot of concern about security and confidentiality, But there's also just this sort of inertia that happens because they get these legacy platforms and it takes a lot of work to move off of a legacy platform. They've customized it, they've changed it, they built it just the way they want it. So we've seen here in 2025 something interesting happen, which is the CEOs of a couple of big companies basically say, sorry, but we're going to pull the plug pretty soon on our legacy platforms. You need to move to the cloud. This happened with Aderant, a company that has a 50-year-old, one of the oldest legal technology platforms, a business management platform for mid-sized to large firms. Their CEO at his conference earlier this year said, if you want to take advantage of everything we offer now, if you want to take advantage of everything generative AI offers now, you need to be on the cloud. And it happened with Relativity, the e-discovery company that, again, for years had an on-premises platform, but it built a cloud platform in 2018, and very slow at getting people to move to its cloud platform. So its CEO put out a blog post, actually, earlier this year in which he said, time to get off. In 2 years, we're going to pull the plug, and we're not going to allow you to start new cases on the legacy platform anymore. So lawyers are at once the cutting edge and often on the trailing edge. Then the second point I want to make is that the best legal tech solves real problems and fills real needs. I cannot tell you how many times I have had a demonstration from a lawyer who wants to show me he was working, he or she, working in his law practice and came up with an idea and ran out and hired a developer and built a product. And the product solved a problem that lawyer had, but not one anybody else had. Or I have somebody call me up and say, I have just launched the first ever whatchamacallit for legal. And I say, but did you know about these other ones that also do that same thing? Well, no, I didn't. You need to, if you're going to launch a legal tech product, you need to do a couple of different things. One is you just need to ask, does this actually solve a real problem and a problem shared by others? And second, has anybody else tried this? And if so, what happened? The greatest sort of catastrophic example of this that I've ever covered and written about has been involved this company Atrium. Does anybody know about Atrium? Atrium was a company, was something that launched in 2017, 2018 with the promise of revolutionizing legal services. It was launched by a guy named Justin Kan. Justin Kan was a Silicon Valley wonderkind who developed and sold the company Twitch, a video streaming company, sold it to Amazon for like $1 billion, basically $980 million or something like that. And apparently Justin did not like the experience he had with his lawyers over the course of that deal with Amazon. And so he decided he was going to start his own law firm. But of course, with rules against non-lawyers owning law firms, he couldn't start his own law firm. So he decided to start a dual entity company. And so there would be the law firm over here, there would be the tech company over here. The tech company would do all the business side stuff for the law firm. And he would own somehow the whole package. It launched with huge fanfare. It raised something like $100 million right out of the gate from some of the biggest VC firms in Silicon Valley. And within 3 years, it was out of business. And interestingly about that company was that what Justin Kan apparently did not realize was that just a few years before he launched that, there had been another company, ClearSpire, that had done exactly the same thing in exactly the same formula. It almost seemed that he had stolen the idea, stolen the blueprint precisely from ClearSpire. ClearSpire also went out of business after about 3 years and failed phenomenally. Justin Kan kind of shut this down very quickly, and then later he put up a post on Twitter in which he said, things didn't work out as planned, and that is my responsibility. So he took credit for it, but really I think the problem was he just didn't do his homework. So lesson 3 is sometimes it's best to pivot. And maybe had Justin Kahn had some senses about him, maybe he would have realized that if his company wasn't working too well, he might have wanted to pivot in a different direction. But what I have perceived over the years is a number of companies that started off in one direction and found that that wasn't going to work, and they move and go off in a different direction, and it works out. And again, another quick story, but another great example of this is the company Casetext. Some of you might have heard of Casetext. But Casetext started in 2013 wanting to provide a free legal research service that would someday put Thomson Reuters and LexisNexis out of business. And the way they were going to do this was through crowdsourcing. And crowdsourcing was the idea that they were going to get their users, they wanted to get law students, they wanted to get lawyers to come in and annotate cases, write notes about cases, link to other cases and articles, and create the kind of robust legal research library through crowdsourcing that Westlaw was able to do through their editorial staffers. Well, unfortunately, that's another one that didn't work out too well. They had a lot of trouble getting participants. They had some people engaging with them, but not very much, not enough of a critical mass to make it work. And they kind of tried various ways to get people involved, but it just really wasn't working for them. And for a number of years, Casetext was struggling. They were not making a lot of money. They were not a financially successful company. They had great ideas. They had raised some good money, but it was a struggle for a while. And then at some point, they decided, well, maybe we should look to AI to do what we can't get humans to do. And through a fortuitous circumstance, as they started to play around with AI, it turned out that one of the founders of Casetext had some connections to somebody at OpenAI, just as OpenAI was preparing for its initial launch of ChatGPT. You may remember that ChatGPT was launched in November 2022. And well before that was launched to the public, Casetext had access to the technology and was able to start building on it. And shortly after ChatGPT came out, Casetext in, I think it was February of 2023, came out with CoCounsel, the first ever AI-driven legal assistant for lawyers. And it was they built a really good product. It was a pretty cool product and unlike anything ever seen. As a matter of fact, it was sort of such a big deal when they launched it. They announced it on the Morning Joe national TV show rather than at a legal tech conference or something like that. As you all may know, the rest is kind of history. Just about 4 months later, I think it was, 5 months later maybe, Thomson Reuters gobbled them up, acquired them for $650 million. So this company that had been struggling for a decade suddenly comes out with a product, and 5 months later it gets acquired for $650 million. And of course, the irony there is that they got acquired by the very company they started out hoping to put out of business. So my next lesson, my next thing I want to talk about is the idea that there's no such thing as the legal industry. And I think this is probably obvious in a sense, but I get calls all the time from VCs who want to chat because they've heard the legal industry is hot and they want to invest in it. And they want to talk about the legal industry. And I think what many, not just VCs, but many in the legal industry don't realize is that there is no single legal industry. The legal industry is a complex group of many niche markets with their own nuanced needs. There are big firms, there are small firms, there are immigration lawyers, there are PI lawyers, there are legal aid lawyers, there are government lawyers. I mean, we understand that. But a lot of people tend to think about technology for the legal industry as if they can develop something generic and serve everybody. And that's really not the case. I think one kind of interesting example of that we're seeing right now involves personal injury lawyers. PI lawyers have been a niche who have not been very well served by technology over the years, frankly. There have been plenty of tech products that have come out focused on personal injury lawyers, but they've been pretty rudimentary, some case management tools, that kind of thing. All of a sudden, with the advent of generative AI, we've seen dozens, literally, of new products come out in the last couple of years, all focused on personal injury practice. You may have heard of Eve is one of them. I'm blanking on the names of some of the other ones, but there have been Even Up, Supio, a ton of these products that are able to help personal injury lawyers with all the kinds of stuff, routine stuff that the lawyers don't really want to be doing. It can help generate discovery requests, respond to discovery requests, draft all their litigation documents, search through huge collections of documents to find that needle in the haystack they're looking for. Really powerful tools, all enabled by generative AI and serving a group that hadn't ever been served before, and also bringing in a whole bunch of VC money. I think, was it Even Up, just a couple weeks ago, raised $150 million on top of, I think it was a Series B. They've already raised several rounds. Eve just raised $103 million on top of several rounds. So there's a lot of money pouring into a sector that's been long overlooked. Lesson 5 is the greatest driver of change is the client. We are in a time when law firms have heads of innovation. They have entire departments devoted to innovation, to technology development, to technology exploration. And if you look around, you might have the sense that law firms are themselves sort of the drivers of all of this innovation. And I think the truth of the matter is that that's not the case. The truth of the matter is that law firms are basically responding and trying to put on a good show because their clients have been pushing them to innovate. Among bigger firms, this has come from the corporate sector, where corporate legal departments have been demanding more transparency, more accessibility, more reporting, better electronic billing, better tracking of work done, better tracking of who's doing work. Law firms have basically been forced to respond. But it's not just big firms. It's happened kind of across the sector. If you look at the solo and small firm sector, and one great example is what's happened because of the pandemic. Before the pandemic, look at the smaller firm market, most smaller firms were still sending out paper invoices and getting paper checks in the mail. And to the extent there was, lawyers were using electronic payment services, they were using one company, LawPay. That was pretty much it. They own the entire market. Come the pandemic, clients didn't want to be going to the post office. They wanted electronic payment services from their lawyers, and lawyers were forced to move in that direction, whether they wanted to or not. And it caused some interesting disruption of that market, where LawPay was once kind of had a monopoly on this. All of a sudden, we started seeing a whole bunch of startups or new companies offering electronic payment services, such that LawPay had to pivot that word from a couple of slides ago and go off in a slightly different direction. LawPay clearly still does electronic payment services and does it substantially, but what LawPay did is went out and acquired a whole legal practice management company. In my case, which owned a bunch of other, immigration platform, personal injury platform, a bunch of other tools, and then they became a whole new company. And just, a month ago, 2 months ago, they rebranded to 8 a.m., which is kind of a weird name, but that was what they chose because they had to get pay out of their name, basically. They wanted to be no longer be seen as a payment company. So again, examples of where the client is driving change in legal. The sixth one I want to talk about is the idea that the justice gap is a technology failure. And I imagine a lot of people here understand that we have an access to justice crisis in this country. The number that gets thrown around most of the time is that something like 92% of people with legal problems can't get help with those legal problems. And study after study has demonstrated that we're never going to solve that problem by throwing more lawyers at it. If every lawyer in the country did a whole lot more pro bono than any of them are doing right now, it would still make only a small dent in the justice gap. And study after study has shown that the only way to really make a meaningful gap in this, a meaningful gain in this, is through technology and the use of technology to enhance the delivery of legal services and legal help and legal information. And yet, that hasn't happened. 12 years ago, the Legal Services Corporation commissioned a study on how to use technology to close the justice gap. And it came out with a blueprint for how to do that. If you look today, 10 years later, at that blueprint, almost none of it has actually been implemented. Parts of it have been. But overall, most of what that study laid out has not been implemented. And why is that? The big reason is cost. The big reason is money. As I mentioned before, even though there's a lot of investment money coming into this field, it's all going to big law and big corporates. I call it the legal technology justice gap. You don't see a lot of investment in tech for smaller firms, for access to justice, for legal aid. When you think about the fact that the principal source of funding for legal aid development and for legal aid technology development in this country is something called the TIG grant, the Technology Initiative Grant that's given out by the Legal Services Corporation every year. And the total budget for TIG grants every year is $5 million. Now, I just mentioned $100 million investment in a PI firm, $100 million in another firm. A $10 million investment is like a seed round for a startup that's focused on big law. And that's the principal source of money for tech innovation at legal aid. So we have to do better. There's a lot of ways we can do better. Law schools can do better. There are a lot of law schools that are innovating in terms of trying to work on developing access to justice programs and tools, and I applaud them for doing that. But we need to do better on that front. Lesson 7 is that regulatory reform is key to unlocking innovation. This kind of goes hand in hand with the last point, but I think we probably a lot of the people in this room have probably heard about reform efforts in Utah and Arizona, which happened in like 2020, and we all thought that was going to be the dominoes dropping, and it was going to happen all across the country, and it hasn't happened all across the country. But the problem is that rules are still in place all across the country that prohibit private investment in law firms and private ownership of law firms. And without the ability for private companies to invest in the delivery of legal services, the innovation in that sector is limited. The key to unlocking innovation is to loosen those rules so that we can get more investment into legal services, into the delivery of legal services. There's been studies after study, again, of what's happened in Utah and Arizona, where they have loosened the rules, where entities can become licensed to deliver legal services. And in the latest study came out from Stanford and showed that the reforms in Arizona and Utah have spurred new business models, new service providers, that a majority of the entities authorized in those states are serving individual consumers and small businesses. And most importantly, probably, there's been absolutely no evidence of any harm to consumers, which is the argument we keep hearing, that if we allow somebody other than lawyers to own legal delivery services, that consumers are going to be harmed. There's absolutely no evidence of that. All right, number 8, tech ethics is harder than you think. One of the most exciting things from my vantage point that's happened over the last 30 years has been the recognition that competence in technology is core to being a competent lawyer. As you probably know, back in 2012, the American Bar Association amended the rules of professional conduct to recognize this. As a matter of fact, Andy Perlman, who I think was here earlier this week, was critical to that happening, was a principal author of all of that happening. But I think that there has been, this hasn't been taken seriously enough by most lawyers. I think a lot of lawyers think, well, if I know a little bit about tech, I'm fulfilling my requirement. I think there's 2 key points that a lot of people don't understand about the so-called duty of technology competence, as it's come to be known. One is that it's not just about the tech you use in your law office. Again, I think some lawyers seem to think, well, okay, If I figured out how to do a pivot table in Excel, then I'm okay, and I've mastered my tech competence. You need to understand your client's technology. It's critical that you understand the tools that they're using when you're representing them so that you can evaluate their data security, so you can evaluate issues that may come up in their use of technology that are relevant to the matter that you're handling. And I think a lot of lawyers really don't seem to understand that. And even some of the ethics opinions that have come out have been unclear on that. Some have been very clear about it, others haven't. And then the other part about it is I think that if you read the ethics opinions that have come from states and from the ABA on this issue, there's the point they all make is that this duty of technology competence is much more broad than just understanding tech. It's about protecting the confidentiality of client data. It's about being able to supervise your staff on a case, the people who are involved in a case, your colleagues on a case, third parties you bring into a case. And you can't do all of that. You can't manage the tech. You can't supervise people if you don't understand the tech. You have to have a pretty sophisticated understanding of tech to do that. So I think that we need to have a better understanding of tech ethics than I think a lot of people do. All right, number 9, Gen AI changes almost everything. I guess I've kind of maybe already made this point, but I really want to make the point that of everything I have seen over the last 30 years in terms of how the impact of technology on the legal profession, I think we ain't seen nothing yet compared to what's about to happen. We are seeing advances in technology that are far more dramatic already, that are far more dramatic than anything we've seen before. Just to kind of, this is a odd little story, but just to illustrate it, I was at a conference 2 weeks ago, ClioCon, the Clio conference. And I don't know, Clio started as a law practice management company serving solo and small firm lawyers. It has continued to grow, wanting to expand into the mid-market, and then now formally wanting to expand into the large firm market. Essentially, it wants to be everything for everybody in the legal space. But over the summer, Clio made big news when it acquired VLEX. Big news in part because it paid $1 billion. It was the biggest deal ever in legal tech. And VLEX was a company that started as a legal research company, acquired Fastcase, another legal research company, a few years ago, and began developing generative AI tools with some pretty sophisticated tools. And VLEX's sort of distinguishing factor is that it has the largest database of international law of anybody, bigger than West or Lexis. And they were actually founded in Barcelona, and so they've started as an international company, and they built up this amazing database. So at ClioCon a couple weeks ago, Jack Newton kind of laid out his vision for how generative AI is going to drive the next generation of law practice. And he started spelling out how they are bringing together Clio, which has always been a business of law platform, with VLEX and Fastcase, which are more practice of law platforms insofar as they drive legal research and a number of AI-driven tools. And how, as he put it, this transforms the technology from systems of record, meaning we store your documents and store your data, to systems of action, meaning it can actually anticipate what you need as a lawyer and perform the actions as a lawyer. And when he finished kind of talking about this vision of what's going to happen, he made the point, this is all today. We're already doing all of this stuff. This isn't all off. A lot of it's off in the future that they continue to build, but most of the stuff he talked about was happening today. And the funny thing that happened at the end of that talk was that people were dumbfounded in the audience. It was a huge audience of 2,800 people sitting there. They were just kind of dumbfounded. I think a lot of lawyers just didn't realize what's happening to how generative AI is going to change their practice. And there were literally 2 people who came up to me afterward and told me they were in tears during his talk, which doesn't happen during a CEO keynote very often. And they were in tears because they felt that everything they had been seeing was possible with tech was finally actually happening, and that we were on the verge of this whole new generation. So that brings me to my final point here, which is the most powerful force in innovation is the storyteller. And I don't mean this as a self-serving point, since I am a writer and storyteller, but I think the point is that progress happens when we can tell better stories and when we can help lawyers understand what law can be versus what it is, what law practice can be versus what it is, how we can better serve clients. And not to harp too much on Jack Newton, but I kind of had him in my mind a lot, and I was thinking about the fact that this kind of defines Jack Newton and Clio in a sense, because when Clio started in 2008, they were not actually the first. Everybody says they're the first cloud-based practice management platform. They weren't. There was another one that launched almost the same week called Rocket Matter. Larry Port, a good friend of Matt and mine, and I love Larry. But one of the differences between Larry and Jack is that Jack was always able to tell the story of the vision of where he saw this going, how he saw this developing. And he became a crusader, in a sense, really for his company, but that's never how he portrayed it. He was telling the story of how technology can change law practice, how it can help us serve our clients better, how it can help us serve society better. The motto for Clio is changing the legal system for all, I think is the motto. And again, by being an effective storyteller, we have Clio is now one of the biggest legal technology companies in the world, if not the biggest at this point. I'm not even sure. Rocket Matter is pretty much gone. So I think that portrays that a little bit. All right. Before I wrap up, I know I've been going long, but I want to just kind of quickly give you a couple of pieces of advice that I kind of pull out of all of that, and then I'll let you get to the bar over there. But number one is be curious before you're certain. And whether you are still in law school, whether you end up as a lawyer or an entrepreneur or a technologist or whatever else it is you might want to do with your career, the greatest asset you have is your curiosity, I think. Technology will continue to change what lawyers do, but your job will be to continue to keep asking questions. Be curious, be inquisitive, be skeptical. Ask, what problem does this solve? Who benefits from this? Do your homework. Who doesn't benefit? The most effective legal professionals and the most effective legal technologists of the future will be the ones who know how to ask the right questions. Second, understand technology, but don't worship it. You don't have to be a coder to be successful in technology, but you do need to understand the fundamentals, as I talked about before, and you need to understand how tools like AI and analytics work and what they can do and what they can't do. So you need to build digital literacy, learn the limits of tech, learn the possibilities of tech, but be clear-eyed about it. And always ask, again, how does this help my client, or how does this help lawyers' clients? How does it help a court? How does it help consumers? How does it help the community? And next, follow non-traditional paths with confidence. As I said, I'm somebody who kind of followed a non-traditional path throughout my career. I haven't even told you all of it. I've had a few other variations along the way. I opened a law practice in the Virgin Islands for a while, done a few different things. And pretty much at every turn, when I did these various things, when I went to the Virgin Islands, people said, "Are you nuts? You're going to go practice in law in the Virgin Islands?" And then when I left the Virgin Islands, they said, "Are you nuts? You're going to leave?" When I started writing about tech and devoting myself to tech, people said, "Are you nuts? You've got a good career over here in journalism. Why are you doing that?" But I think that the point is that there was, the people used to talk about alternative legal career as sort of a pejorative almost. Today, it is a growth market. There are lots of roles for legal professionals to work in ways other than practicing law. There's product strategy, data knowledge, innovation, compliance, ethics, marketing, operations, UX, and much more. All of this is core to how legal services are delivered, and they are increasingly valued. So always remember, there is no single path, and there is no correct path to making an impact on the profession or on the world at large. Next is the justice tech is the frontier that needs you the most. I've been talking a lot about this, but I think a lot of people go to law school not because they want to get rich, but because they want to make an impact on the world. And if you're one of those people who is driven by mission, this is your moment. There are real opportunities to do important work in the tech sector by working kind of on the margins, where tech and AI meet: eviction defense, immigration, family law. We're seeing a new wave of innovation starting now that really focused on ordinary people. You can join that wave, or you can help change the regulations around it, help fund it, help improve it. Next, number 5, two more. Get involved in reshaping the rules. Again, I think it's really critical that we reshape the regulatory structure in this country. Whether it's the sandbox experiments in Utah or the tech competence rules in Puerto Rico, the next generation of lawyers will not just practice under new rules, you will have the opportunity to write them. You have a voice, use it. Whether it's lobbying for non-lawyer ownership, sandbox programs, or just clearer AI regulation, get involved, be an advocate for change. And finally, be a translator. Tech doesn't change legal practice on its own. It's people that do. The best innovators are those who are bridge builders, who can speak both law and technology, who can understand users, and who can explain complex tools in plain English. That might be you. Help your firm understand why innovation is necessary. Help clients see how technology improves outcomes. Help courts, regulators, and funders understand the risks worth taking. Tell better stories and help inspire innovation. So, as I look back over these 30 years, I've learned, I think the key takeaway for me is that legal tech really isn't a product story, but it's a people story. I've learned that innovation is not about expanding how much we can serve people, but how we serve them. And I've learned that the profession moves forward when new voices speak up, when new minds engage, and when people like you enter the field with vision and courage. The future is being built right now, and you are the ones building it. I look forward to seeing what you do next. Thank you for your time.
I want to ask Bob if I can steal all of that. Can I just steal it? So good. I want to thank you for incredible reflections on your career and on technology, and I think offering us a pathway to understand how this is going to affect us and how we can navigate this new landscape. And so your words of wisdom are amazing, Bob. Thank you so much. We will have this posted on our website so that others who are not here can learn from you, and I certainly have, so I'm grateful to you. Terrific.